Good morning again, everyone. My name is J.D. Keister. I'm with McAngus, Yaudelock, and Curry out of our Raleigh office as the immediate past president, at least for a few more hours. I have the privilege of being the Judicial Committee Chair, and as this is an election year, we are honored to have our Judicial Forum as we have done in the past. I first want to extend a thank you to all of our candidates for making the trip, attending the conference, and being a part of our Judicial Forum. The importance of our judiciary is well known and perhaps never as important as what we have today, especially to a room full of attorneys who interact with our appellate judges and their decisions on a daily basis. So thank all of you for being here. Some brief ground rules, both for the candidates and for the room, very similar to what we've had in years past. We will start with the Supreme Court race, in which I'll have the two candidates come up and sit at their designated seats. They will have 2 minutes. All candidates will have 2 minutes to introduce themselves, talk a little bit about their position and why they would like your vote. And then we will have a question that will be, at least one question will be given to each of the candidates, and they will have up to 4 minutes to respond. The Supreme Court candidates have been given 2 potential questions. The Court of Appeals candidates have been given 4 potential questions. When the Supreme Court candidates are done, we have 5 of the 6 Court of Appeals candidates here. The 5 will come up. I'll have their seats laid out. If there is an incumbent in the race, the incumbent will be sitting on this side of the stage. The incumbent will go first, and we'll have the other candidate go second. Judicial candidates, a couple of additional ground rules or things to point out. This is the only time that I or we as lawyers get to put a clock on you. So please don't hold that against me, but I do have my phone up here. We have a very strict schedule that we're going to try to stick to. So if you hear my iPhone alarm go off, that may be a slight clue that it's time to wrap up. Also, while there may be and generally is a time and place for true back and forth debate and perhaps limited commentary on your opponent, we ask that not be today. We would like for you to focus on the issues and the questions that have been asked that are important to the NCADA. And we have tried to craft questions that are both important to our judiciary, but also to this group of attorneys, trial lawyers that represent companies, businesses, and stakeholders throughout the state. So without further ado, I would like to invite our candidates for the North Carolina Supreme Court seat, Associate Justice Seat 1, Anita Earls and Sarah Stevens. Justice Earls, Representative Stevens, please come on up. And our candidates, again, we're going to violate all the court rules today. We're going to have the lawyers keeping time on you, and we can go ahead and probably staying seated is probably going to be easiest just where the microphone is. First, an introduction from the candidates. Justice Earls, you can go, and I'll start the timer.
Well, thank you. Good morning. My name is Anita Earls, and I'm honored to serve you as the Senior Associate Justice on the North Carolina Supreme Court. Thank you so much for this opportunity to be with you this morning. I first ran for the court in 2018 after 30 years as a civil rights attorney. I did that work in just about every possible practice setting. I started out in private practice in Charlotte. I also was a Deputy Assistant Attorney General in the Civil Rights Division in the U.S. Department of Justice. I worked in several public interest law organizations, and I decided to run for the court because I understood how important our state courts are. During that time in practice, I had jury trials in civil and criminal cases. At the appellate level, I argued cases in the 4th Circuit, the 11th Circuit, 1st Circuit en banc, and numerous cases in the Court of Appeals and North Carolina Supreme Court. I did a little research, and I think my numbers are right, that since 2010, this organization has filed amicus briefs in the Supreme Court in 37 of our cases. Most recently, in 3 of those cases, filing amicus briefs at the petition stage as well as the merit stage. And I just wanted to emphasize how important that is to the court. And whatever happens in November, I hope you will continue to do that. It's important as we try to decide what cases to hear from this body. Was that your club?
It was not.
Okay, one more thing I want to tell you. And that is, in addition to my record on the court in the opinions that I've written or joined, I've also worked to try to improve the administration of justice. Most recently, as an advisor to the Equal Access to Justice Commission, looking at what we call the justice gap, the difference between people who need legal advice and the resources available to serve them. And our court has created a new commission on practice innovation, and I serve a co-chair of that commission with Justice Berger. Thank you.
Thank you, Justice Earls. Representative Stevens.
Thank you and good morning. Again, my name is Sarah Stevens, and I've been an attorney for 40 years. Started my own practice as soon as I graduated from Campbell Law. Did a bunch of things in my first 3 years that should make all of us shudder. I tried a shareholders derivative action to a jury, got a verdict, a good verdict, had to chase it to bankruptcy court in the Southern District of Florida. And then I tried a medical malpractice case, got it directed verdict at the close of the evidence, and took it to the Court of Appeals and got it overturned. You know what? In the first 3 years of practice, that's not a good thing to be doing, but it certainly taught me a lot of experience. The bulk of my time then was in family law court, and there is no one on the Supreme Court that understands family law or has been an active practitioner. For the last 17 and a half years, for those of you just saw, I just resigned from the North Carolina Court of Appeals. So I've had the opportunity to advocate. I've had the opportunity to legislate. And now I'm concerned that I've seen the court system go a little too far activist. I want to be a Supreme Court justice who will remain a constitutional conservative and who will go with a strict interpretation of the Constitution. And it's not a place to be making law. We make law when we get the input from all of you, and we have 120 people throughout the state that help us in the House and 50 in the Senate, and that's where law should be made, not in the court system. So that is my primary function in running. If I've got just a second more, Justice Amy Coney Barrett, I think, said it best. She, and I'm paraphrasing, a judge is a referee, not a king. A judge is to ensure that the laws were followed, the rules were followed, and the law as it was written, not as you want it to be. So it's to ensure that we stay in our lane. Thank you.
Thank you. All right, let me change this timer to 4 minutes. So that the audience is aware, one common question was given to all of the candidates. And if we have enough time, I'm going to ask them to address that topic very briefly, and then they're going to be given one more substantive question. And the one universal question really kind of goes with what you're seeing in Daniel's great programming, dealing with technology and generative AI and kind of what the position is of the judiciary or our candidates on those issues. So if we have time, you're going to hear the same question asked to all of our candidates about technology and artificial intelligence. But first, I want to ask our Supreme Court candidates the following question, and Justice Earls, you will answer that first. When the language of a statute is clear, but the result seems potentially against public policy or may infringe on constitutional rights, should a justice focus exclusively on the text enacted by the legislature, or may broader policy considerations play a role, and if so, how? Justice Earls, let me hit my timer. You may begin.
Thank you. This question is, when you start out with when the language of a statute is clear, that decides the answer. Because when the language of the statute is clear and there's no ambiguity, there's no role for the court to interpret. We apply the clear language of the statute as it's written. So that's sort of full stop. If there's no ambiguity, there's no need to apply rules of statutory interpretation or construction. We apply the clear language of the law. I will go a little bit further to answer what I think might be part of what's motivating this, and that is what if it's a little bit ambiguous as to how it should apply, and then do we focus on policy considerations? My answer is no, and that comes from our case law. Our Supreme Court case law is clear that if there is ambiguity, so not when it's clear, but if there's ambiguity, we then engage in statutory construction, the goal of which is to accomplish the legislative intent. And then how do we figure out what that is? We go back to the language of the statute. We look at the spirit of the act. We look at what the act seeks to accomplish. All of that is the court's function in trying to figure out how, whatever this ambiguity might mean, what was the intent of the legislature. So the only time that there might be a challenge is if the language of the statute does in fact contradict a constitutional right. And there our duty is always to uphold this state constitution. And so you might read in some of our opinions where we say, you know, we reject an alternative, again, where it's ambiguous. Language is ambiguous. We reject an alternative interpretation because that would create a conflict with the state constitution. But generally, if the language is clear, we apply the law as it's written.
Thank you. Representative Stevens.
Thank you. And I really appreciate Justice Earls' answers because that's in a way a lot of the answer I would give. The problem is we've had activist courts that are not doing that. When it talks about infringing a little on the Constitution, that's not something we should tackle either. The Constitution's pretty clear about what it says, and so if you feel like it's infringing, then you still shouldn't tackle that. The law is the law. Again, the general statute, the statutory construction is we assume the statutes are constitutional. They must be clearly shown to be unconstitutional in order to make that changeover determination. We can look at them too in terms of context, not just policy, but in the context of how it's done. We don't change a statute at the court level unless it proposes to give us an absurd result. Beyond that, we stick to the law as written. And there are lots of ways, and again, having been in the General Assembly, there are lots of ways we can get to the statutory intent. All of the statutes have been sent through committee that are recorded. We can go back and get those histories. We can get the bill summaries of what they intended this law to be. We can follow the law. And that's what this is about. The problem is we've had some activist judges who've said, I don't care what the law says. I think this is unfair and we're going to do it my way. Fair is their definition of fair, not the law. Now, in terms of saying it feel like it violates state policy, well, state policy is set by the General Assembly. That's all the more reason we follow the law as it is written, not as we want it to be.
Thank you. I'm going to ask the candidates to try to do this in about 90 seconds or under, just so we can keep on track. Courts will increasingly confront issues, and are confronting issues, involving artificial intelligence, algorithmic decision-making, digital evidence, or fake digital evidence. How can and should a court balance these technological innovations with established legal principles when precedent is limited or does not yet exist?
4 quick points I'll make here. First of all, I do think that our normal rules, courts have in the past had the experience of having to confront new technology. Our normal rules about how you establish chain of custody, how you establish reliability, how you establish when scientific evidence, new scientific evidence can be admitted into evidence. We have rules that say all those things, even if we haven't applied them to artificial intelligence. I think the second point, really important, judges must understand the technology in order to figure out what rules we should be applying and this applies whether you're talking about evidence to be introduced or changes in rules of procedure or other issues in administrating the courts. Third, I'll say we have dealt with some analogous situations. For example, we recently had a case that dealt with a confrontation clause challenge to the introduction of machine-generated data. And so I think as our court is beginning to have some precedent in this area, that will be analogous. And finally, I'll say, I think it's important that we hear from the bar. So again, if we're making decisions about rules of practice or other issues impacting how our courts operate. Other state court systems have already put in place some AI policies, including appellate courts, but I think it's vitally important that we hear from all of you, that you have really important information that will help us make rules that serve the legal system the best. Thank you.
Thank you.
Thank you.
Season?
Thank you. AI is going to be a very important addition to most of our law practices and to most of our lives. But the thing is, we can't depend on it. We are the intelligent people who have the common sense and the ability to go in and analyze what AI has put out for us. We've seen cases and heard of cases where people submitted briefs based on AI, and the information in it was incorrect. It is still our responsibility to be that person to our client, not AI. If not, can you imagine we get to a point where the judge is a computer sitting here and there's a plaintiff's attorney computer sitting there and a computer sitting there, and then they just battle it out. That's not what it's meant to be. We have to keep this thing very personal. When it comes before the court system, we do have rules of evidence, we have statutory construction, we have things that we have done in the past, and so we have to sort of tackle this issue one at a time. I do know that the General Assembly, just this past week, has been looking at AI in numerous areas of how we handle it. If you lose all credibility with a court by bringing in some AI that's digitally manufactured, that is a false narrative, you've just hurt your credibility terribly with the court. And I'm assuming that the bar is going to up and set some procedures and some parameters that this will affect your license if you continue to rely too heavily on AI. It's a great tool, but it's just a tool. The same as someone was talking about email. It's a tool, but we've seen some of the abuses through the emails. Online banking is a great tool, but we've seen some difficulties with that, and we have to be prepared to focus and face those issues with AI as well.
Thank you both very much. Our Court of Appeals candidates can come on up.
Should be you, right?
This is me. You even spelled my name right. Everything's coming up right.
All right, let me get the timer ready here. So we will do this seat by seat. So our seat one candidates for the North Carolina Court of Appeals are Judge Arrowood and Judge Michael Byrne. Judge Arrowood, I'm going to give you 2 minutes to introduce yourself, and I'll start the timer now.
Good morning, and thanks for this opportunity. I am Judge John Arrowood, and I'm pleased to be here with you today. After I graduated from law school at Chapel Hill, I clerked for Gerald Arnold at the Court of Appeals, was a staff attorney and the head of the staff. And then for over 25 years, I was an attorney at James McElroy and Deal in Charlotte in commercial litigation, where I dealt with many of the things that you all deal with today. I did some class action defense work in the automotive industry. I did some insurance defense work for Lawyers Mutual, and that's the only insurance firm I would say that I've dealt with. But I know that many of you have those things. I've been on the court as a Superior Court judge and at the Court of Appeals for over 11 years. My record is fairly evident and easy to find. You can see over 600 opinions I've written. Some of those you're going to agree with, some of those you're not. I think, though, that you can look at what I've read and see, what I've written and read and see how I decide cases. I've also been happy, while I've been on the court, to be a part of the Appellate Rules Committee. I've, for the last 6 years, been on the IOLTA board and currently chair that board, and I've recently been happy to have been at the Practice Innovation Committee as one of the Supreme Court appointees to that, dealing with how do we deal with legal deserts. I would appreciate your support. You can learn more about me at keepjudgearrowood.com. Thank you.
Thank you, Judge. Judge Byrne?
Good morning. Thank you very much for having me here today. I'm very grateful for the opportunity. I want to thank Judge Arrowood for his presentation and his service. I'm an administrative law judge, have been for the past 6 years, hearing a wide variety of cases. Some of them are very simple turnpike, we hear those. And then I hear certificate of need cases that involve, a dozen attorneys and 3 weeks of hearing. So it's a very, very satisfying job. Prior to that, I was an attorney representing primarily police and public employees. Did more than 25 cases in the Court of Appeals and Supreme Court. That gave me a very good background for my present job. The Court of Appeals is a workhorse job. It's not a show horse job. In my job now, I've written over 400 opinions. I've been appealed to the Court of Appeals 9 times, and I've never been reversed. Someday that streak will end, but not today. Simply put, I was hired by Judge Julian Mann, who was the director of our office for 32 years, and he gave me a one-sentence directive: Michael, get it right. And that's what I try to do. I hear cases involving agencies headed by both parties, and I treat them all exactly the same, because the most important thing simply is fairness. Thank you.
Thank you, Judge. Get this timer to 4 minutes. And again, we will start with you, Judge Arrowood. This relates to business climate in North Carolina as an organization that represents businesses around the state. Businesses often cite predictability and consistency in the legal system as important factors when deciding where to invest and where to grow. What role does the judiciary play in maintaining a legal environment that promotes economic growth and stability while ensuring access to justice? Judge Arrowood.
As an intermediate appellate court, there are several rules that the North Carolina Court of Appeals judge follows to ensure consistency. First of all, we have the precedent that comes from the Supreme Court. Secondly, there's this case, as all of you know, called In Re Civil Penalties, that says that if one panel of the Court of Appeals has decided something, that all the panels there subsequently are bound thereby. So there is a consistency there. There are also rules of construction that are very consistent with what the statutes say and how they are written and how do you interpret them. But more importantly, and an issue I think we're now facing in North Carolina and in our court system, is when I was in private practice, my business clients and my individual clients, they all wanted to know when their case came to the Court of Appeals that it was going to be decided, and it was going to be decided timely. I am concerned that our court system seems to have slipped, and we're no longer consistently living to the 90-day rule, because I had many clients who said, I want to know I want to win, but I also want to know what the court's going to do, because if the court decides against me, then I can then plan out my life. I think it's absolutely critical to businesses and to individuals that our court systems again return to getting the cases decided correctly, but more timely.
Thank you, Judge. Judge Byrne.
Judge Arrowood is correct on that. In our office, one of the reasons I became an administrative law judge was I said, we need to get these cases decided quickly, accurately, fairly. And the Court of Appeals is the same way. I mean, I represented people for years who didn't have jobs, who lost their livelihood, and they waited around literally for years to get a decision. That's not right. Judges need to do the job, get the work done, get the decision out. Now, in terms of the consistency, in re civil penalty obviously controls that, and it should. There are cases in my own background where the Court of Appeals would rule one way one year and one way another. Thankfully, they're rare. But I think what you need to have as lawyers appear in front of either our office, the Court of Appeals, Supreme Court, whatever, is the knowledge that you're going to be treated fairly, you're going to be treated consistently, and you can get predictable results based on precedent. And I don't think anything about that is controversial. The following the rule of law is a basic premise that you just be consistent, be fair, be honest, and don't take sides. That's my philosophy.
Thank you, Judge. Judge Arrowood, again, if you can, 90 seconds-ish or under. The same generative AI question and topic of how you see generative AI and the court's role with generative AI, lawyers' usage of generative AI in the coming years from the Court of Appeals.
Well, we do not have a policy yet. I do know that lots of law firms are putting policies in place, and I was just talking to some lawyers the other day of how they're putting policies in place to make sure that when they use AI, that they use it correctly, and that we've seen cases at the Court of Appeals where we've had hallucinatory cases. We also see a wide range of motions and petitions now, mainly from pro se folks, using generative AI. But in your practice, what I would say that when you're deciding whether the courts are deciding what's going to come in and what's not going to be admissible, we go back to Rule 702, and we look at the standards of Daubert and Quomo Tire, and those are the things that are going to be, I believe, applied in this area as well for whether evidence is admissible and whether it was properly admitted in the trial courts.
Thank you, Judge. Judge Byrne.
I was talking to Dean Martin about this. When I lived in Asheville 25 years ago, everybody was worried that Y2K, the plane's going to fall out of the sky. And they didn't. The law has never done a good job of keeping up with technology. And AI is simply no different. Eventually it will. I see the same hallucinatory cases in our office. There is nothing more exciting and entertaining than a pro se petitioner armed with AI. They can actually do some pretty good stuff. But as someone said earlier, there really is no substitute for your knowledge, for your brains, for your intuition. It's a tool. It's like any other tool. And in 10 years, somebody will be sitting in this room talking about the latest technological whiz-bang, and this will sound kind of quaint. But the law will deal with it, and the law will move on.
Thank you, judges. Next, we're going to turn to our Seat 2 candidates for North Carolina Court of Appeals. We have Judge Toby Hampson, who is here today. Judge George Bell could not be here today. He is holding court in Mecklenburg County. And because he is holding court, we made the decision to allow Judge Bell to submit written answers to the questions that were posed to the Court of Appeals. So Judge Hampson, you'll have a chance to introduce yourself and then give your response to the question that I'll ask, and I will read Judge Bell's response as well. The floor is yours, sir.
JD, thank you. Lynette, thank you for organizing this. It's great to be amongst so many friends and former colleagues in this room. I am Judge Toby Hampson, one of your North Carolina Court of Appeals judges. It's been an absolute honor to serve you over the last 7.5 years. I grew up down in Moore County, mostly down around Carthage, attending North Carolina public schools. My mom taught math at Sandhills Community College, so she was very disappointed in me when I went to law school. But after law school at Campbell, I began my career at the North Carolina Court of Appeals, clerking for Judges Eddie Green, Wanda Bryant, Bob Hunter, before going into private practice with Patterson-Dilthey. And I see a lot of my Patterson-Dilthey colleagues here, where I really focus my practice on trial and appellate work, particularly civil defense litigation. After a few years at Patterson-Dilthey, I joined Wyrick Robbins, where I really focused my practice on handling appeals, primarily in our state court of appeals, state Supreme Court, then to a lesser extent, a little bit of federal appellate work. But I really learned how I handled all the kinds of cases the North Carolina Court of Appeals hears, everything from criminal cases to representing indigent parents whose parental rights are at risk, to complex commercial business litigation cases, workers' compensation cases, medical malpractice cases. So I really think I brought a lot of relevant experience to my work on the court. Since being elected in 2018, I've written over 400 majority opinions on that court and a few dissents and concurrences along the way. I'm certified as a specialist in handling appellate cases by the North Carolina State Bar Board of Specialization Committee. So I love the work of the court. Deep down, I'm just one big appellate nerd. I love the research and writing and getting down into the weeds and feeling how luxurious it is to actually get to do that on the court. So I look forward to this discussion and look forward to continuing to serve you on the North Carolina Court of Appeals. Thank you.
Thank you, Judge. We're going to stick with you. Let me get timer to 4 minutes. For the seat 2 question, large verdicts, nuclear verdicts, have received national attention. They were slow to come to North Carolina, but we've seen them here. What role should our appellate courts play in ensuring that jury verdicts are both respected, but also consistent with jury instructions and established legal principles?
Well,
Go ahead, Judge.
First, as I think we all do, I believe in our jury system, and I believe in a jury's ability and a power to reach the right result, to take in all the evidence, to read the verbal cues or nonverbal cues, and really get down to the right result. And as we all know, in and of itself, it's really hard to get a jury verdict reversed on grounds of things like passion and prejudice or even inconsistent legal theories. But where we do see jury verdicts being reversed is where the wrong legal framework is being applied, where jury instructions are incorrect. For example, I actually was able to, in practice, get a $91 million jury verdict reversed in the North Carolina Court of Appeals precisely because the trial court was applying the wrong legal standard and allowing evidence in that allowed the jury to base its jury verdict on what evidence that should have been inadmissible. A $91 million case, which probably should have been an $8 million case on the plaintiff's best day. So, I think what we take from that and what I see now on the court and what I try to take on to the Court of Appeals in writing my opinions is that, we need to craft clear, precise opinions that are consistent, not just in the results that we're reaching, but also in the language that we're using, pulling from prior precedent to make sure we're finding that consistency through the law. Number one, to allow lawyers to prepare their cases and prepare their evidence consistent with that law, but also then to allow judges and lawyers to craft good jury instructions that helps guide a jury, helps direct a jury, and really kind of reins in the jury's ability to kind of decide those cases under undue passion and prejudice. So I think it really falls on our courts to craft clear, precise, consistent opinions. Thank you.
Thank you, Judge. I will now read Judge Bell's response to that same question. As a sitting Superior Court judge for approximately 8 years, I have presided over many civil jury trials. Early in my judicial career, I was fortunate to have skilled defense lawyers educate me on nuclear verdicts and plaintiffs' trial tactics and attempts to provoke primordial emotional responses from juries known as the reptile theory. In particular, I recall defense lawyer John Spainhour played a part in my understanding of this topic and providing the court with helpful studies and information to help guide the court in making a determination of what arguments would be permissible for a jury to hear. Since I have the experience as a trial judge, I understand that the role of an appellate court is critical, where a trial judge allows irrelevant theories like reptile to invade the minds of jurors, which could potentially cause verdicts based on emotions and not on the facts and law as required by North Carolina law, causing a nuclear verdict. If elected on the North Carolina Court of Appeals, I will review the record to determine if a Superior Court judge may have erred in allowing inadmissible evidence and irrelevant evidence like reptile theory presentations. I will carefully examine the jury instructions, evidentiary rulings, expert testimony rulings, and other legal decisions that may have caused a nuclear verdict and exercise my authority to order a new trial as justice requires. Judge Hampson, the same generative AI question that has been asked, if you have some additional comments on that, we'd love to hear them.
You know, I was at a meet and greet with some voters a few months back, and somebody asked me, well, Judge Hampson, what would the founders and the framers of the Constitution contemplated about these AI license plate readers? And I thought to myself, my goodness, the founders probably didn't even contemplate license plates. But that's kind of the brilliance and the resilience of our legal system, right? It's what the law does is it gives us these fundamental principles, these building blocks, this precedent that you can use and analogize and apply to an ever-evolving society with AI. And so I think it's going to be really critical that as we address these issues as courts, that we do, as Justice Earls said, we look to our evidentiary rules and our current procedural rules and our statutes to help guide us along with that precedent to make sure that as we advance with these principles and work in tandem with this technological innovation, we're still tethering it to fundamental basic legal principles. And I think that's the beauty of our system. It gives us the flexibility to do that through our common law.
Thank you, Judge. And I will again read Judge Bell's response to that same question. As a Superior Court judge, I have recently just begun to see an uptick of artificial intelligence in my courtroom. Just yesterday, while hearing civil motions in Charlotte, a pro se litigant presented the court with an AI-generated response that mistakenly said 2 cases had been overruled when in fact the cases were good law. So as a judge, I realize that technology is coming, but the court needs to act as a gatekeeper and carefully examine pleadings, motions, and arguments that are likely flawed and incorrect. When precedent does not exist, the court should understand that while new technology may emerge, the court should not abandon traditional judicial principles like going directly to the text of the statute and determining the legislative intent, using trusted methods of research, and making sure that our own judicial system is protected from technological error. Finally, we will turn to our seat 3. Our candidates are Judge Christine Walczyk and Judge Craig Collins. As there is no incumbent on this seat, I did a coin flip in the room. And so there's either that or rock, paper, scissors, but figured the coin flip was slightly more professional. So Judge Walczyk, you will go first.
Thank you so much for having me here with you today. My name is Judge Christine Walczyk, and I was born in Raleigh. We moved around. My dad worked for IBM, so I spent most of my childhood in South Florida. I graduated magna cum laude from Boston College Carroll School of Management with a concentration in finance, and I came back to North Carolina when I went to UNC Law. Now, earlier in my career, I owned my own law firm. We typically did small business work, employment law, everything from business formations to contracts to civil litigation. This was before we had a public defender in Wake County. I'm dating myself, so I was also on the indigent appointment list, and I did some defense work for juveniles and adults that were charged with crimes. So I got this job in 2007. I have been there 19 years now on the district court, and in that time I've been nominated for leadership positions by 4 different chiefs, both Democrat and Republican. So I served many years as our lead family court judge, and for the last 5 years I've been our lead general civil judge. And in Wake County, what that means is I'm just standing in the shoes of the chief to handle all the arbitrations, the court-ordered arbitrations, and I'm doing the local rules and the policy for those courtrooms. And in my career off the bench, I have spent my time trying to support women in this profession. I think we make good judges and good lawyers. Been on all different kinds of women's organizations like NCADA and the Women in the Profession Committee with the Bar Association. I'm also on the National Association of Women Judges. And, you know, we've tried to encourage women to stay in the profession. We've nominated women for awards and recognition. I've also tried really hard to level the playing field for self-represented persons. So I helped launch the Legal Support Center in Wake County, still on their advisory board. And more recently, I've been really working hard on judicial independence. On the National Association of Women Judges, I serve on the Judicial Independence Committee. And what we do is we create civics education materials for lawyers and judges to use in their communities. And we also go around the nation training judges about how we can improve trust and confidence in the judiciary. And that's one of the reasons I'm running. I'm worried about the public's loss of trust in the judiciary. I'm worried about the politicization of the courts. And I hope to bring independence, integrity, and balance back to the court. Thank you.
Thank you, Judge. And Judge Collins.
Good morning. It's great to be here with all of you. My name is Craig Collins. Since graduating law school, I've held 4 jobs in the legal community. Spent 9 years as a prosecutor, 9 years running my own law firm, 9 years as a district court judge, and I'm currently a superior court judge. I think it is vital that we have judges who don't just say the right thing at campaign season, but understand that we need to follow the Constitution as it's written, follow laws as they're written, and not just come up with results that we may like them to be. I think it's incredibly important that when you adopt a case, the first time a client walks in, that you know what the standards of law are, that your trial judge is going to know what the standards of law are, and that whatever decision happens can be upheld because they knew what the consistent standard would be. And so I think that's the most vital part for this group when looking at judges, not just the ones that will say that those things, but I have a career of A, supporting judges who follow those philosophies, and B, as a judge, enacting those policies to make sure that we have the results aren't result-oriented as a judge, but legally oriented, to make sure that we're looking at the law as it is, not as we may wish it to be, that we follow the Constitution as it's written, and that we follow the statutes as written. And so I think those are vital issues, and I look forward to getting to know some of you a little bit more. I wish I could stay around for the whole weekend and the whole conference, but I have other responsibilities, but I did leave literature out on the table, and I hope that you'll pick that up. Check out my website at votecraigcollins.com. Again, that's votecraigcollins.com. Check that out, and I'd love to have your support.
Thank you, Judge. The question for Court of Appeals, Seat 3. There has been increased societal and political pressures on the judiciary, especially in the last decade. Some believe courts should adapt legal principles to address modern societal issues, while others believe those changes should come primarily or solely from legislature. Where do you fall on that spectrum? Why? And how will you handle the political and societal pressures that come with sitting on the Court of Appeals? Judge Walczyk.
So this is a great question. First of all, I believe the legislature is responsible for making our laws, for setting policy, for making budgeting decisions. But if they are not meeting their constitutional requirements or they're acting outside of the bounds of the Constitution, then I think there's a role for the courts in ensuring constitutional compliance. And what I think this question is really about is my judicial philosophy, so that's sort of the way I'm going to answer this question. I believe in the rule of law. I believe in equal access to justice. I believe in due process, both procedural and substantive. And I believe in judicial restraint and precedent. I think our society needs consistency and stability for a safe and peaceful society. And so I think we should exercise great caution when we are overruling cases of the same or a higher court. But at the same time, I think there are going to be times where our Constitution and our laws have to be interpreted in the context of evolving societal norms and values. And so, you know, I don't like the labels, the interpretive approach labels that people give to us. I don't think judges say, I'm this kind of a judge or that kind of a judge. It's usually people who are critiquing us that use those labels. I don't subscribe to any singular interpretive approach, but I just try to apply the law faithfully, and you know, I pay careful attention to the words, but I also pay attention to the purpose of the words and the practical consequences of the words. And so, you know, I think that you know, I don't like the idea that we're limited to the framers' intent or what the Constitution meant only at the time it was written. I mean, our job as judges is to apply the law to real-world situations and real-world social constructs. And so I don't think we can do that if we're stuck in that time period where slavery was in effect and women had virtually no rights at all. So I think that there are times where we are going to be, I mean, just to give you some examples, you know, when you talk about free speech, I don't think the framers, like the license plates, had any idea that we would be dealing with social media or computer code. And if you talk about the Fourth Amendment, I don't think they had any concept of air tags or listening devices or those things. And so it's our job to apply these laws on a daily basis to our real world situations, and that's what we try to do.
Thank you, Judge. Judge Collins.
Okay, I appreciate this question. It's exactly why I'm running for a Court of Appeals. I'm a constitutionalist. Words say what they mean what they mean, and the courts should not be changing that. If you want policy decisions, we go down the street from the Court of Appeals to the legislative building where policy is debated on the House floor, the Senate floor, there's votes cast, and those legislators go back to their home district every 2 years to explain those votes to their voters. It shouldn't be decided in judicial chambers with 2 judges on the Court of Appeals deciding what the policies should be. I'm not running for a policy-making decision. So what policies I may prefer as a voter, really it doesn't impact where I'm at as a judicial candidate. So if you want policy, we need to debate that with our legislators and when we're electing them, not with our judicial candidates. So I don't believe that the courts are the place to tackle those issues. I think that the issues need to be decided by the legislature and not by the courts. And that's one of the concerns that I have of those political societal pressures that the question asked about of, are we going to have a court that bends to those pressures, that writes law, writes policy decisions in the courts, and then what's our remedy? When the legislature writes a policy or a law that we think violates the Constitution, we have a remedy and we take it to the checks and balances process of the courts. But when the courts write those same policies, what's our remedy? And that's the danger that we have. Judicial candidates who then face statewide races every 8 years don't have that accountability. Policy making should be accountable to the voters every 2 years. Legal decisions are clear-cut. The Constitution says what it says. It doesn't say what it doesn't say. And the statutes are going to say what they say and not say what they don't say. So it's the main reason I'm running, because we do not need a judiciary that wants to be a super legislature. We cannot have a judiciary that bends to political and societal changes. That's the legislative responsibility. And I do not want to be a legislator. That's why I'm running for judge. That's why I have run and I am a judge. So I think that this is an issue that there's a clear difference here. And so I'm asking for your support, because we cannot have a court that wants to write laws. When we do, we will in fact have a constitutional crisis. And there's no remedy to that we can see coming up in the future if the courts are going to write those laws. So thank you for that question.
Thank you, Judge. And finally, the same technology in the courtroom, generative AI. I'm sure that both of you see that in your courtrooms already, but how do you see the judiciary being involved in that, and certainly at the appellate level if you were elected?
Thank you. Yeah, I'm sure Judge Collins will agree. We're seeing this already. I mean, I've had cases with voice cloning. I've had cases with AI-generated photos on social media. You know, we've had Bitcoin with the key lost and trying to value Bitcoin. I mean, these things are coming up on a daily basis. And I anticipate that we're going to be having more cases about the ethics of AI, property rights with AI, AI data centers. So this is coming, and I agree with Justice Earls that we have to be educating ourselves on these issues and at least understanding, you know, we're not going to be experts on it. You guys, it's going to be your job to present these things to us with your experts or otherwise to show us sort of how the technology is working and how it's affecting your clients. But we need to educate ourselves and make sure we can at least understand what the innovations are and how society is using them. And, you know, it's going to be, I almost look forward to being on the appellate court to have some chance to research these issues rather than doing it on the fly when they come in front of me that day and I had no idea what the issue was going to be. But, you know, I think we just need to do a balancing test of the need for the technology with also protecting people's rights to privacy and security and those kinds of things.
Thank you, Judge. Judge Collins?
Okay, so I think there's two issues really here that come into play. First is we need clear, consistent, predictable rules for you when you're in front of a judge. And as a trial judge, your trial judges need clear, consistent, and reliable rules to make sure that evidence is coming in that's fair and make sure that we're treating the parties as fair as possible. These are issues that are ongoing and quite honestly changing by the moment. And any answer that any of us give today might not be a valid answer for tomorrow with how fast this area is changing. So we need to make sure that we're studying that. We need to give clear rules. I think that we can't avoid using technology, but we have to be very careful of fully trusting it. As a practitioner in the courtroom and as a judge, we used to be able to just trust what we saw and heard, but we can't anymore always. So we have to make sure that we're adding indicia of reliability to make sure that the evidence that is coming in is reasonable and fair. As a judge, I think the biggest concern, and also in your roles, is to make sure that while we're embracing technology as it changes and using it, and we can't be afraid to do that because it'll put us behind if we do, but we cannot substitute artificial intelligence for our own legal discernment. And I'll never do that. I'll never turn that over. What I do fear of some movement in this area is that we'll end up in a position of where we plug things into a computer and it gives us our results. And obviously that's not a result that any of us would want. And I pledge to, while I will embrace technology when I can, I will never turn over my legal discernment to a computer.
Thank you, Judge.